All right. Good afternoon, everyone. Thank you for joining us for this webinar. Definitely want to welcome everyone that's joining us online, anywhere you are, whether you're in Texas or outside of Texas or anywhere around the world. My name is Lorraine,
And I'm Elon,
and
and
together
together
we are
we're
Elaine
Elaine
Law
Law.
Group. Awesome. And so I want to talk today. We're going to be talking about some topics that a lot of business owners, a lot of creative professionals, Elon, we get asked about NDAs all the time. And so we want to really kind of dive right in so we can kind of illuminate this topic for the business owners and the creative professionals we work with. This is our agenda for today. Obviously, we're in the welcome introductions portion. We will then move into some of the core protections. Later, we'll discuss the limits of NDAs, as well as the practical risks and common pitfalls, best practices, and of course, Q&A. So let's go ahead and get started. All right. Um, so let's talk about, the core protections that should be in an NDA. And this all pretty much revolves around scope and enforceability. First of all, what is an NDA? It's a contract that defines what type of information is considered confidential and how it can be used or restricted, um, and what that looks like, right? So the scope of an NDA typically talks about what type of information is covered, and also other types of information that sometimes people may not believe is confidential or proprietary, but it could be. If you have a business and you have a supplier list or a vendor list or customer list or a certain way you go about doing things, you might feel like it's common sense, but if it's unique to your business, and it's something you develop over time, that in fact could be considered proprietary. Some of the categories that we talked about here, and they're listed here: client list, financial data, technical processes, and prototypes. These are all types of things that could be potentially an NDA. I think, Elon, one of the common things that comes up also sometimes is even in the food business, right? Classic example: a recipe cannot be patented, but it's basically a trade secret that should be protected through a contract framework, which includes NDAs.
Mhm. Exactly. I agree 100.
Absolutely. Awesome. And then when we talk about enforceability, when you have contracts, that means that people understand their obligations, their rights and obligations, and how the dispute is to be handled while the parties can align on things rather than after the fact. And then the lines are very murky, right? And so, if you have an NDA, there's some of the things that a court will typically look at to determine whether or not it's enforceable. One, is it reasonable, right? Whether it's reasonable in time, reasonable in limitations, reasonable in geography, things of that nature. It's really important to strike a balance, to make sure that you're not being unreasonably restrictive. And we hear about this in non-competes, and we could do a whole workshop on non-competes, but we won't get into that today because we're focused on NDAs. So let's quickly talk about the limits. I think this is a good segue for us. What can't be protected? Elon, do you want to expound upon this?
Sure. Anything that's already out in the public information. I think even though that's quite obvious, a lot of people don't exactly do all of the research to see what's already in the public scope or in the public sphere, to know that it cannot be restricted or protected via an NDA. Mainly because those things are already free and open use to the public. Independent discoveries and things that other individuals have already created or discovered, or we lost the presentation.
All right, just a second. Let me
But anything that's already been discovered by another individual, I think what people have to understand is that every single day, other folks are creating new and innovative ways to do things, especially those hot button items that are really like top of the market types of trending things in technology and any type of sphere that you might be in creative spaces, industries. Industries are always evolving and people are always creating things. So things that are independently discovered by another individual um, cannot be legally enforced via an NDA. So if Lorraine says she's going to create a new way to bite the apple or something or dissect the apple, and I say, no, I'm creating a new way to do the same, and we end up coming across similar ways of doing so, then that can't necessarily be protected via the NDA. Sorry, I have a co-star. Um,
No worries. And I think another aspect of it, of course, is reverse engineering, and we think about
yeah,
this a lot of
definitely.
times in patent world as well, where you have a product or a service that's out there in the marketplace. Generally, this is about products, though. Even if you have a trade secret or you have a patent or what have you, right? If it can be deconstructed and then created through the learnings of that deconstruction, that is not going to be protected, right? Because that is not within the realm of disclosure and recipient of the disclosed information.
What I really also want to talk about, specifically highlighted here, is that intellectual property rights. Um, an NDA does not beget an intellectual property right. So, like, just because you create an NDA or you're doing something in a space that you believe should be a, a secretive location or secretive business, but you've created this NDA for your employees to abide by or your business partners to abide by, etc. If those things then are not also backed up or enforced by a trademark, a copyright, or a patent, then you don't necessarily have those intellectual property rights that will be granted to those types of registrations. They are very separate and apart from the NDA itself. They help to certainly strengthen an NDA. They're actually, go hand in hand. You should be also applying for or receiving secured certifications for those trademarks, those patents and those copyrights because you want to make sure that you are truly protected all the way around, so that individuals that do have insight into your proprietary information are not also stealing your entire company or your entire work. But they are complementary, but they are not the same thing. An NDA does not create then an intellectual property right.
Thank you so much
Um,
for flagging that, Elon. That is so very true and so often misunderstood.
yeah, yeah, most definitely. And then lastly, obviously, you want to make sure that it's not overly broad. Things that are like saying, "Oh, um this is basic contract law though too. Um, this NDA is covering all works or all things that are created during the course of business, exchange, etc. It's not specific enough to meet what most courts are going to be looking for is what exactly are you saying should be enforced by this non-disclosure agreement, because you can't, you simply can't throw the whole a net or cast a whole net around something that does not, just meet up to the standards that are required by law. So you just want to make sure that you are drafting or have an attorney like us to draft the NDAs to specifically discuss or meet those items that are actually taking course during the course of business.
Absolutely. Transition to the next slide here. So some common risks and pitfalls that we see all the time when we get these contracts to look at. generic templates. The Google Grad School, YouTube University is real. And sometimes people will come to us after the fact, after they have a signed document, and just being perfectly candid, it doesn't really protect them the way they want and need, right? And so you really want an NDA that's specifically tailored to your business, because that is going to provide you the most coverage, right? And you as a business person, right? You might be thinking, "Oh, I've read it. It seems like everything is covered." And you are going to be the expert in your business. I mean, that is certainly a fact, but you're not an attorney, right? And so there might be certain terms of art that you may not be as familiar with, or certain types of protection that you should get that you may not be aware of that you're entitled to, right? Depending on your specific legal situation. As Elon mentioned, if you have registered intellectual property, right, versus unregistered intellectual property that's protected by, contract regime and trade secret realm, right? So I think that's, super important. As she mentioned earlier, failing to clearly identify what is confidential information, right? Anything and everything discussed is not necessarily confidential information. So that's a big flag. Omitting certain remedies. So, for example, if you're the prevailing party and there's a lawsuit, you want to make sure that there's a prevailing party clause in there, so that if you do have to enforce for some reason, you can recover your expenses to enforce, whether that's attorney's fees, filing costs, different types of expenses that you might incur to enforce it. Of course, damages. Sometimes with uh, an NDA specifically, sometimes you could get injunctive relief depending on the facts of the situation, and that's injunctions obviously part of that. I think this also goes to something that Elon was bringing up earlier, and I think I've discussed on the reverse engineering. An NDA alone cannot stop competitors, right? Is a tool, but it is one tool in a complex set of a toolbox, right? You might use a hammer for certain things and a wrench for something else, or pliers for a different situation, right? And contracts are, no different. And an NDA is a tool, but certainly not a standalone armor, so to speak. Okay, and let's talk about best practices, Elon. Can you guide us through those best practices?
Yeah, absolutely. So you want to strengthen your NDAs through some of these best practices. Number one would be hiring an attorney to create those NDAs, as Lorraine mentioned, no Google grad school. And now it's Chat GPT created NDAs and contracts and things like that. But you want a context to be customized. So you want to customize for context, meaning like, is this an employee relationship that we're discussing? Is this a vendor relationship that's at question, or are these investors? And if these people are coming into the relationship, how is their different relationship you know, curtailed and customly created in this or drafted in this NDA to actually speak to that relationship. So that's what we mean by customized per context. And you want to then clearly categorize all of your confidential information. Like we said earlier, don't want to be overly broad, or in this case, you don't want to be too vague when discussing various items. So in the text industry, um, in in the tech industry, you want to make sure that those items are completely thoroughly lined out and specifically spoken to, so that it's not leaving any gray area when we're discussing various aspects of your tech. I just think about tech because Afro tech is coming up. So anyway, and then you want to pair your NDAs with all of your other agreements that you might have anyone within your business create. So non-competes might speak to employee relationships, even vendor relationships, and investor agreements as well. They can also be incorporated in the NDA, I'm sorry, can also be incorporated in some of these different types of agreements. So your non-competes can include an NDA or NDA clause or NDA language, same as your IP assignment agreements and your employee contracts. So the NDA shouldn't be always considered as, oh, this extra thing over there, but you also want to have some NDA language incorporated in all of these types of agreements as well.
And that is such a great point. And it actually reminds me of, the sample case we had on the prior slide, Ho Kuz versus Stephen Sucharski. Pardon me if I mispronounce anything there. But it makes me think about some of the companies, right? And as business owners and also, high level professionals, right, within a company, these are things that you need to be aware of. And, in that case, basically the company had an employee, a high level employee, join the company, but they did not have the appropriate documents in place in terms of the matrix of documents required to protect that confidential information. Unfortunately for the employer, they relied on the handbook. Well, the handbook is something that can be updated as policies change and therefore does not constitute a contract, right? And so in that case, they didn't have the employee sign the NDA as part of their onboarding packet, which certainly, if you're a client at Elaine Law Group, we would not have you doing that. We will have you have really tailored employment contracts and agreements with your team members, your vendors, what have you. They make sure that you're right and tight and protected as much as you possibly can be. But anyway, basically, they didn't have the employee sign the requisite documentation. And at the end of the day, the court basically found that they couldn't hold the former employee to the confidentiality requirements because the documentation necessary was not in place in terms of the restrictive covenants that would have been established by the non-disclosure agreement. And so that kind of just goes back to your point, Elon, about so important to have a professional look at these, make sure that they're well drafted. And even if you're on the employee side, if you want to make sure you're protected, even if you don't own a business, you should contact a law firm that handles business law to help you negotiate terms that are more favorable or fair to you, right? And so thank you for bringing that up because it just reminded me of that case.
Yeah.
At this,
One thing I also want to talk about on that in that case is also just the sheer refusal to sign, right? Like what happens when
Mhm.
an employee or individual you're engaging to either come in as an investor or what have you refuses to sign your NDAs. You want to, in that case, my first thought is always limiting the amount of access these individuals do have to your proprietary information. So you want to make sure that you have those safe walls in place to kind of create like a human firewall kind of a thing that is keeping people out of that proprietary information until they have actually agreed to the terms of your NDAs and your employment agreements, and just kind of scaffolding the type of access that they may have. If it's like a must have them now kind of a situation, then you want to limit the type of access that they have based off of the security clearance kind of a thing. I know sometimes that's hard for small businesses, but you still want to make sure that you're only giving people as much information as they really need to do their job. You don't want to give them the whole run of the entire, um, I would think of, you don't want them running all over the mansion in their muddy shoes and messing things up. So you want to limit them to this room over here. You want to put them over here in the guest room only and, lock all the rest of those doors. So kind of think along those lines when people are refusing to sign.
Absolutely. So with that being said, and thank you for flagging that because that's another really important thing for leaders within businesses to be aware of. I want to go ahead and with the time that we do have left, we've got about 5 minutes left to open it up for questions. I know that we have some people who are attending the webinar. Obviously, we will post this recording for the benefit of the community at large. But wanted to just open it up for any questions. If anyone has any questions, We are monitoring the chat and the Q&A to see if there are questions. Okay, and I do see a question that has come in. The question says, if I am an employee, I'm summarizing, if I'm an employee and I've already signed an NDA, what are my options, right? Um, Elon, do you want to start on that and I can, follow?
Well, first thing I would have done, even prior to signing anything, if you're able to always have an attorney review those documents prior to signing. But now that you've already signed, now you can still take it over to an attorney, have them review it, and help to explain what your rights are, or those rights that you have kind of relinquished in signing that NDA. If you're concerned that you have violated that NDA in any way, sometimes as an employee, the safest space is the HR department in your company. If you don't have an HR department, then you need to be contacting an attorney to see what your rights are. Have you violated anything, etc.
Awesome. Thank you, Elon. And I actually agree. I think being forthcoming in those types of situations is best. Obviously, no one can guarantee a particular outcome, right? But it's better to be forthcoming and disclose versus to not disclose. And, eventually it's discovered and then there's another problem, right? I think the other thing to think about is what is it? Like, what is the so I'll give you an example. There's a very popular, I think, a story that a lot of people talk about. I think they made a movie on Netflix. I'm not sure what platform it was, but the Flamin' Hot Cheetos, the guy who essentially invented the Flamin' Hot Cheetos, and so he was working at Frito Lay or Doritos, one of those companies, and he was kind of his side of the story is he was batching and making these things, on his own time, not at work. Um, but his role at the company was not within the scope of what the work product he produces for them would have been, right? And so again, that's all the more
Yeah, I
reason why
think
these contracts are important.
he was like a janitor or something, right?
Yep,
Yeah.
yep.
And clearly Frito-Lay has their entire um, you know, food department. He wasn't in that department or that experimental food and equation, whoever is the chemist are that's creating all these recipes. He wasn't in that department. That wasn't the same scope.
Absolutely not. And so even if they had him sign an NDA, right, to the point we've been bringing up earlier, it wouldn't have been in scope, right? Maybe that NDA would have covered, the secret chemical cleaner that they use to clean up the manufacturing floor or something like that. So, that is something to always, if you're in that situation regarding that question we got earlier, also it depends on what was the scope of what was it disclosed. Just because you disclose something that's a finding that you independently develop, like what we mentioned earlier, that may not fall within the scope of your NDA. So it really kind of depends, and we advise that you reach out to a lawyer. I see here we've got time for one more question, and we do have one. It says, do NDAs ever restrict the free flow of information? For example, clauses that prevent employees from discussing salaries or companies from disclosing acquisition prices. Why are these provisions still legal in some cases, and how do courts treat them? Elon is a judge, so I'm going to hand this over to her first.
I'm not that type of judge. However, yeah, so if I understand the question correctly, I think this is a little bit more leaning towards the employment law side of things, which do have a little bit different reasonings behind the laws. I'm definitely taking a wild shot in the dark at this one, but what happens is you don't want a hostile work environment created by companies discussing things like salaries. I'm sorry, by employees discussing things like salaries. So it's more leaning towards like the HR side of things and why companies are trying to create more of a I guess like the reasoning behind the law it outweighs it weighs more in favor of the benefits of a working environment. However, as far as acquisition pricing and things like that, sometimes those are done in private settings that are able to be and in those terms of those acquisitions, it's is in the terms of those, it's stated that you cannot discuss the pricing or of the acquisition, but it also helps to stabilize the market. So what you learn in law school is that every rule has an exception. And it's in the exceptions that we're able to make our clients happy, for the most part. So that's kind of some of those gray areas. But as far as the free flow of information, intellectual property in itself, and the governing and even the registration of intellectual property in itself, kind of is one of those things that does kind of hinder a free flow of information. However, they all have term limits. That's why we were talking about earlier, discussing, making sure that things are reasonable. Those limits are not overly oppressive or overly restrictive to the individual that's signing them, because we don't want to violate exactly what you're speaking of, the free flow. So where you might be restricted for a limited period of time, like maybe 5 years, 2 years, or something like that, the court is not likely to uphold something that's for a lifetime or for 20 years or 30 years, right? Those are a little bit overly burdensome, and will most likely be struck down. So we try to have a nice balance. Those scales of justice are balanced, but they're not always just, one sided, right? So it's about a spirit of fairness. Hope that helps.
No, it does. And just one little caveat I want to add in there, we are licensed Texas attorneys. Texas's approach to employment law is so different than a lot of other states, and there are some states that are similar to Texas. And so, with that being said, there may be laws on the books in some other states, probably more progressive states, that allow employees to disclose and have paycheck fairness laws and things like that of that nature. But in Texas, that's not the case. So that again, or another reason to consult an attorney that's licensed in the state in which you reside or you're working, because all of those things, could obviously impact you. But I know that we're at time here. I want to thank everyone who has joined us online. Obviously, we'll be posting this workshop. You see our contact information over here, our phone numbers. We have both the Dallas and the Houston office. And no matter what office you're trying to reach, we can be found online at ElaineLawGroup.com. Our email, our handles are all there, and would love to see you on a one-on-one if you need our support. Thank you so much for joining us today.
Thank you. Bye.